right? But this whole section is on securities fraud, and it digs a little bit into some of the Securities Acts that we should probably already have a little bit of familiarity with. You know, the 33 and 34 Acts kind of wraps things up with some of the schemes. So kind of boring at the beginning, boring-er in the middle when it starts talking about the Patriot Act and all this other stuff, and then it gets interesting when the fraud schemes kind of finally come out. So, all right, so they define things for us to begin with, and they're nitpicky with some of this definition, and we have a list of things that are classified as a security, and that becomes important because certain laws apply in certain situations. So a security is, a boring definition, a negotiable financial instrument that represents an interest or a right in something else. Things like that are hard for me to remember because it's just like boring, nitpicky definition. So it's some kind of financial instrument that you can sell and buy, and underlying that is some interest in something or a right in something. And things that are classified as securities are stocks, buy and sell those, bonds, CDs, futures and options, derivatives, notes, treasury stocks, security futures, evidence of indebtedness, investment contracts, etc., etc., etc. It may or may not be worth kind of getting the very basics of these types of securities definition-wise. You probably already know, right? You know what a stock is, you know what a bond is, you better. You know basically what a CD is. You probably know what a future is from finance class or something. So, you know, you may not want to waste your time reading up on what those things are, but a general idea wouldn't hurt. So once we classify it as an actual security, then it falls under some pretty heavy rules and regulations. Their inclusion of so-called investment contracts as a security in the definition gives them some leeway, gives them a way to lump in other financial instruments that aren't specifically listed in the definition to be also included. And we have a test, the Howey test, 4-factor test to determine, is it an investment contract and therefore a security? So that test is it an investment? Is it an investment in a common enterprise? Is it an investment in a common enterprise where there is an expectation of making a profit if you're an investor? And is that derived from the efforts of somebody other than you, the investor? So those things would make it an investment contract and therefore security. And that gives us the ability to classify Ponzi schemes, right? It's an investment in a common enterprise. They're expecting a profit, and it's going to be derived from efforts of somebody else. Pyramid schemes, prime bank note schemes, investment schemes involving all this other stuff, partnerships, joint ventures, pretty much anything they want to classify, right? So again, here they are in the bigger bullet points to kind of talk about what some of the oddball things are. We already know what Ponzi and pyramids are, so we don't need to talk about that again. Prime bank note scheme, you know, trading those things. Viaticals, good definition to know, easy test question to ask. We may have already mentioned it in the past when we were talking life insurance or all the insurance schemes and stuff, but a viatical is a terminally ill insured person is selling the death benefit of their insurance policy to a third party. That is called a viatical. Note that. That's an easy test question. A limited partnership is a considered security. A general partnership is not. I'd put a star by that too. That's a really easy test question right there. Limited partnership, security. General partnership, no. Right. Joint venture, typically a security. Sale of all these interests in minerals and oil and gas also. So pretty much everything we've mentioned here except a general partnership counts, right? International Organization of Securities Commissions. So this is the standard setter for the securities market. they have a set of principles and regulations and things. Not sure how important that is, but you have? Okay, so sometimes I'm iffy on it, but usually when I'm iffy, I'm like, yeah, I'll stick it in there. You never know. So you haven't seen a review question on it already.
Yeah, they said something about that. At first, it just said the IRS.
Okay, good deal. So it's important. Do you remember the question? Yeah. All right. You're no help.
Sorry. I just remember.
Yeah, nope, don't remember. All right, these Securities Acts, we're probably fairly familiar with these for the most part. The 33 Act regulates the public offering. You got to file a registration statement, full and fair disclosure of information that's material involving the investment, no fraud. So public offering for that 33 Act, right? The 34 Act is going to deal with everything after, right? Trading that's going on after it's offered. There's registration for the dealers and brokers. There's reporting that we have to do. We accountants are familiar with all that. Proxy materials filed with the SEC. You got Rule 10b-5 prohibits fraud, prohibits insider trading, disclosure violations. That rule is used very broadly. Basically, in a nutshell, you can't deceive somebody when it involves a security transaction. Of course, to be fraud, for anything to be fraud, there has to be an intent to deceive. And in this particular case, there has to be reliance on it and damages suffered. So that's not always the case, but it is the case here. But there always has to be an intent to deceive for it to be fraud. And then the 17A rule deals with fraud through the mail, so not nearly as broad as that other. Other acts, you got the Investment Advisor Act of 1940, Investment Company Act of 1940, Sarbanes, we know enough about that. Let the name kind of lead you to what it is. The Investment Advisor Act involves the regulation of the advisors, and it prohibits fraud, right? Pretty much all these do. The Investment Company Act, companies such as mutual funds, it kind of regulates them, right? And I kind of just noted at the bottom, the SEC doesn't have the power to take criminal action. FBI typically handles that. Patriot Act. Something we've heard plenty about in the news, I'm sure, over the years. And I think we may have already mentioned it in here too. So it expands on that Bank Secrecy Act that we talked about a couple of weeks ago, and established even a higher level of responsibility for banks and whatnot. It requires them to have a customer identification program, background checks for new accounts, monitor for suspicious activities. There's a big section on money laundering. We'll hit that later in the money laundering section. It requires an anti-money laundering program. It prohibits foreign shell banks from having accounts with U.S. banks. Banks are allowed under it to share customer information with other banks. They got to fill out appropriate forms, of course. And then it gives federal government greater access to financial records. So a lot of bullet points worth noting on the Patriot Act for sure. Some organizations, the 34 Act authorized the SEC to create and oversee some of these organizations, such as the Financial Industry Regulatory Authority, which regulates all these securities firms that are doing business. All right, the fun part. Some of these we've encountered. I think this one we saw with our practice test on day one. So what kind of fraud schemes with securities? There's churning, the idea of churning stuff out. So excessive trading to generate commissions. What makes it a problem? You're disregarding the customer interest. All right, how do you prove it's excessive? You can apply some ratios and stuff to see if it's kind of out of line. Of course, the key is whether they had discretion over the account. Suitability, you're not allowed to make unsuitable recommendations. You got to know your customer. You wouldn't want to recommend these really high-risk options to senior citizens with not a whole lot of assets. You got to know your customer financially to be able to service that account. So there's a suitability rule. And then I just threw this at the bottom because I don't think they would test you on this, but I thought it was worth noting just for completeness because we already mentioned those ratios. So we apply those ratios, and we would expect an annual commission for an advisor to be 1 to 3% of the assets. So if you get outside of that, it's a bit of a red flag, right? Turnover in the portfolio in excess of 300% would also be a red flag. I don't know that they'd be that specific on a test question, but I thought it was interesting because I like all the analytics stuff too. Okay, selling away, kind of descriptive of what it is you're trading or soliciting the traded securities that your firm doesn't hold or offer. You're not allowed to do that unless you have permission from your employer. That would make it fraud, right? Parking, so again, kind of a descriptive term. Selling a security to somebody with the understanding that you'll repurchase it later at an agreed upon price, so you can, kind of park it with somebody to maybe circumvent some kind of reporting requirement or whatnot. Parking. Unauthorized trading is what it is, right? Just trading on somebody's account without being authorized to do it. And I love the rule on this. Losses from unauthorized trading must be reimbursed. Gains go to the customer. So you got everything to lose and nothing to gain by unauthorized trading. And the opposite is true for who you're trying to use on that. Systematically trading accounts against each other. I thought this was interesting. It's a way that the broker can organize things that would guarantee them a commission. So you have two different pools. You buy for one, sell for the other. One will have a gain, one will have a loss. You get a commission on the gain. You're good to go, right? So you're not allowed to do that. A block order scheme is where you are having big orders of securities in a block for several accounts, which is fine. It's a good, timely way to buy stuff, but things can change very quickly and abuse can happen pretty quickly. So block orders, kind of a risky thing. Market manipulation is where you're transacting in a way to manipulate the market. That's the name, market manipulation. So designing these transactions to artificially or give the appearance of trading activity. They mention it's common with penny stocks. They call them low price, less than $5 stocks. They're registered but don't have the listing requirements of an exchange. So a lot of terms there that are pretty easy to keep straight. Churning, suitability, selling away, parking, unauthorized trading, systematically trading, block order schemes, market manipulation, and then a big section on insider trading. So we got a whole slide on this. We know, yeah, I think so. Yeah, she was arrested. I don't know the specifics of what she was arrested for, but yeah. So trading on the basis of material, of course, but non-public information. So the 34 SEC Act prohibits it. That's worth noting for sure. There's that rule that we mentioned a second ago, and we probably had that on that slide too. Yeah, insider trading. So we've mentioned that twice now. So the classic theory of insider trading is that it involves somebody with an actual fiduciary duty, but then it's evolved over the years, and now we have the misappropriation theory, and I stuck the court case on there just for the heck of it. You don't have to know that, I wouldn't think. But insider trading has been found that it can involve outsiders or temporary insiders, not just somebody with the actual fiduciary duty. And then there's a regulation FD. FD stands for full disclosure. So yeah, definitely remember this. You can't be selective about groups to disclose to. There is an appropriate way to disclose through an SEC form, through a press release, or whatever. So regulation FD for full disclosure. And then wrapping it up, we got front running. So getting out in front of things, using privileged knowledge of a customer's order to buy or sell a large amount. It's a form of insider trading. You've got knowledge that others don't. You get out ahead of it being published, buy or sell before some large transaction takes place that would influence the market. Technology and timestamps and dates and things make that one an easy one to catch. And then backdating stock options is not illegal, but you got to disclose it. And Sarbanes has some additional reporting regarding backdating stock options. That's the important things I noted from that chapter. I think you'd be good to go with what's on those slides for the most part. Questions or comments? Okay, so that was 84-page section. We've narrowed it down to really 14 slides. So that coupled with all your review material, questions and stuff, you should be good to go. All right. Money laundering. This was kind of a fun one to read. Not as meaty as the other one. It's almost as long in page length, though. We ended up with like almost 70 pages. Only got about 10 slides out of it. Money laundering. We know what it is. We see it in movies all the time. It's hiding, your money, cleaning it up. You got illegally obtained money. You want to spend it eventually, but you gotta kind of clean it up so you can put it back out in there. So to put that a little better, you're disguising the existence, nature, scope, ownership, location, disposition of some kind of property you obtained from criminal activity. So you're trying to either eliminate a paper trail or just cloud it up and make it so complex that you can't find out what's going on. You're trying to put some kind of distance, figuratively speaking, between cash or something that you got illegally and you spending the thing, right? So there are 3 stages generally: placement, layering, and integration. So placement, in our book, makes the point that this is usually when it's detected. So placement is introducing the illegal profits back into the financial system. Examples, their examples are kind of funny. Moving money out of the country in a suitcase and depositing it in an offshore bank. That would be placement. Again, you're putting the profits into the financial system somehow. Structuring transactions to make a deposit that will avoid those regulatory requirements we talked about last time. We even talked about what that was called. I put it back in parentheses. Smurfing is what that's called. That would be another form of placement, right? Banks have rules they have to report. With 10,000. So 10,000 what?
10,000 and 1 penny.
Okay, over 10,000. Okay. So placement is getting it into the financial system. Layering it is trying to prevent it from being detected, confusing the audit trail, making everything complex. And an example is moving it through several jurisdictions. And then integration is bringing it back into the economy and making it appear as it is legitimate. So those are your stages of money laundering. Methods. And this you see in all the movies. They got a front business. It's seemingly a legitimate business, but they're using it for maybe a lot of different things. They're cooking the books of this business with the purpose of putting money back out there, right? So they might be overstating their revenues or something like that. But it gets really complex. They may be doing other things in here. They may be overstating expenses. They may be depositing money but not recording revenue, whatever. If the company overstates revenues, you'll want to overstate expenses to offset a tax liability, of course. So, it gets really complex. But overstating expenses is a way to spend money too, right? Spend money, call it some kind of random expense, but it's really going back out to wherever. Buying illegal goods or investing somewhere else, something like that. Favorite businesses for hiding or laundering money. Anything with revenue that's hard to measure, cash transactions, expenses that are hard to measure, and they specifically list the things you see in the movies: bars, nightclubs, casinos, Vending machines, you don't see those in the movies, but that'd be an easy one. Money service businesses, internet gaming, shell companies, charities, nonprofits. Charities is an easy one because a lot of people give money anonymously to charities, and you can really use that to your advantage, right? Why these types of places, charities and nonprofits, anonymous gifts, it's easy to hide stuff that way. Money service businesses aren't as highly regulated. That's a good thing to note. Prepaid items are an easy way to use, illegally obtain money. Like a prepaid debit card you can use pretty much anywhere in the world, and they put a term on that type of deal called open loop. Closed loop would be something you could use for the purchase of stuff from a specific organization or its affiliate, so it's not quite as versatile. You usually can't change it to cash. And then semi-open loop, just kind of in between there. It's like an open loop, but you cannot redeem it for cash. I don't know how important that open, close, and semi-open loop stuff is. It seemed like something they could ask a question on. I put it on there. I don't know. Okay. And then additionally, keeping on with the money laundering methods, there's these black market things, and there's these other little systems, alternative remittance system, where you have a broker and the parties are able to remain anonymous. And for obviously that's a good way to get rid of the paper trail, right? Using this type of system that guarantees anonymity between whoever's spending to where. So that kind of thing's a problem. All right, here's that Bank Secrecy Act again. That's important. So the purpose, preventing, detecting money laundering. There's a system of record-keeping requirements that financial institutions are required to keep, and they're trying to track and keep up with large and weird and suspicious financial transactions. I don't know that I'd commit all this to memory, but I put a note on there just so it could kind of give us a little more of what are they talking about. So you just have to keep records on stuff, basically. Anything over $100, transfers, purchase of instruments over 3,000, any records to be able to reconstruct their checking account for a couple of years, report. And this is the important one, the fourth one there. You got to report anything over 10,000 on an actual currency transaction report. And that's the whole thing where the smurfing comes into place, and they try to avoid that kind of thing. And this Bank Secrecy Act applies to casinos as well. And you monitor suspicious activity, and if you see it, you file a suspicious activity report, which is a report to disclose suspected criminal offenses or known criminal offenses. And then they gave a list of things that might trigger one of those. This is a little much, but again, just for the sake of completeness, I guess, we can sum that up. Some kind of violation over a certain amount, and under a certain amount, even if there's some kind of basis for identifying a suspect. But yeah, in a nutshell, it's any transaction they have a reason to suspect that the funds were from some illegal activity or to evade that Bank Secrecy Act smurfing thing. Office of Foreign Assets Control has a list of bad people. So they have a list of people, government entities, companies, whatever, that are known or even suspected to engage in illegal activities. And there are sanctioning policies against those. And there's blocked assets, and it bans them from dealing things and prohibits them from insurance policies and things like that. Kind of interesting. And there's other federal laws related to money laundering. There's seizure and forfeiture, lets the government take all these things that are involved in crimes. That counts with money laundering. There's the relation back doctrine. When government, when property is forfeited to the government, all rights and interests in the property are the government's as of the time which the crime was committed. So that gives the government entitlement to any gain that came from the proceeds of an activity, illegal activity. So even if it had been sold off somewhere, the government actually owns it. That's called the relation back doctrine. There's criminal forfeiture and civil. So criminal would be an action against a person, and it would be in conjunction with the criminal trial. Civil would be an action against the property, and be independent from the criminal procedure. And then some more groups that have actions against money laundering. We got the UN. We got a financial action task force on money laundering. There's something called the Egmont Group. So, yeah, figured it might be worth noting there. That pretty much knocks out money laundering. Questions, comments on that? This was quick, mainly because we have the background on this to where we don't have to dive too deep into it. We know what tax evasion versus tax avoidance is. So tax evasion is not legal. It's fraudulent. We're trying to avoid paying tax. We should pay. Intent is the key. There has to be, as any fraud, willful intent to unlawfully defeat taxes. Can't be a mistake. And there's got to be willfulness, substantial deficiency, and an affirmative act. So that's tax evasion. Tax avoidance is legal. It is a legal way of lowering your tax bill through legitimate things. So tax avoidance is okay, and we strive for that. Tax evasion is not. IRS is going to pursue civil actions. In those cases, the burden of proof is on the taxpayer. So IRS says, hey, we think you did this. You have to prove that you didn't. IRS doesn't have the burden of proof on that. Criminal is different. So criminal tax cases would be a fraud case. Department of Justice handles that. Burden of proof for fraud is on the government. Those are important things to note. International tax avoidance and evasion. So they make the point that tax evasion is a lot of times accomplished through tax shelters, tax havens, secrecy jurisdictions, and then we define what those are. I think we could probably figure out what they are without defining them, but tax shelter is an investment that's designed to yield a tax benefit. Some investment made to produce a tax write-off or generate a deduction or convert income into capital gains that would be taxed at a lower rate. Tax shelter, we automatically think, oh no, not good, but generally we're trying to legitimately avoid taxes sometimes with tax shelters, but it could cross the line into tax evasion if they involve a tax haven, which is a country that offers favorable tax treatment to an investment. Those can be legal as well. Or a secrecy jurisdiction, which is a country that has laws that they've enacted to afford secrecy and prevent disclosure and prevent people inspecting documents located there. That's a problem, right? Evidence of tax fraud. So direct evidence rather than circumstantial evidence. Direct evidence of tax fraud would be bank deposits that are not explained, false documents that have been submitted, false claims, participation in an illegal business. Circumstantial evidence, not direct evidence, would be where they proved illicit income by showing assets or expenditures are way more than what could be accounted for from the income that you're admitting that you have. So it's kind of a financial analysis of what's going on to say there's no way this could have happened. It's not direct, it's indirect, it's circumstantial, but it is evidence. We also think circumstantial evidence is not a good thing, but circumstantial evidence is fine too. Defenses against allegation of tax fraud. There's no deficiency would be a defense. If there's no deficiency, that means there's no tax liability and you're good, right? Lack of willfulness would be another one, which means no fraud. Still might owe for the unpaid taxes, but you're not a criminal, right? This with avoidance, not evasion, would be defense. Claim of right document, claim that we don't have the right to use this money. This is not my money. That would be a defense. Not my money, not my tax. Or a defense would be reliance on an accountant or attorney. Not saying it'll work, but it's a defense. Statute of limitation, there's no statute of limitation for fraud. For civil actions. For criminal charges, the IRS generally has 3 years to audit a tax return, 6 years to seek prosecution if they conceal 25% or more of the income. Fraud penalties survive the death of a taxpayer. So just because you die doesn't mean those fraud penalties go away. And then a final deal on whistleblowers. There are whistleblower programs that give whistleblower a percentage of what's recovered. So can't see that as a test question, but it's interesting. All right, so that's it. We narrowed tax evasion down to all of that. This was a little longer. Rights during an examination. So we're shifting gears a bit with this one. We've been talking about securities fraud and tax fraud and money laundering, all that. So we're kind of shifting a bit now to what rights individuals have during an examination. Let's see, we got 10 after. Yeah, let's run through this. All right, so employees have a duty to cooperate. Okay. Why would they not have that duty? But employees required to comply, substantially comply with all directions of his employer concerning the service on which he's engaged. Duty exists in every employer-employee relationship. Obviously, it has to be reasonable, it has to be possible, and it has to be lawful. Employees have a duty to retain relevant information in anticipated litigation. Spoliation would be them destroying all that stuff before it's before they get their hands on it. Okay, that's not legal. So spoliation is a term to take note of. It's the act of intentionally or negligently, even if it wasn't intentionally, destroying documents that are relevant to a litigation. All right, so far that's the employee's rights in an examination. Cooperate. Don't destroy stuff that you shouldn't destroy, right? Now, there are possibly contractual rights that can limit the employer to compel full cooperation. So, there can be a contract on a lot of things. So, in general, there's a duty to do these things. But if there's a contract that's out there that says this, 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 and this, then that's the deal, right? So that's going to limit what's generally true. Breach of contract could be part of the deal if the employee was required to do something against that contract that was in place. So these things could come from union contracts, it could come from collective bargaining agreements, or it could just come from a simple, here's the contract between the employee and the employer. They can be expressly written or they can be implied. Just because there's no signed formal contract doesn't mean there isn't a contract that exists. All right. They can dig into company manuals, company policies, and even past practices that can create an implied relationship. All right, here's this stupid thing that got me on mine. I had a test question. The answer was the National Labor Relations Act. I don't remember what the question was, but the other choice was Federal Labor Relations Act. How do you study for something like that? So it's the national. I couldn't have told you still if it was federal versus national before I looked at this slide. That was a dirty question in my opinion, but whatever. I'm pretty sure I missed it, probably. Was it in review materials? You see? Yeah. And that's one of those like, well, I won't miss it again, but it's so close that then you do forget what it was again.
How many things are actually called national?
I know. National, federal. What's the real difference? It's not a good question. But anyway, the National Labor Relations Act, as is in its title, governs the labor relations of most private sector workers, right? Not public sector government workers, but private sector workers. It guarantees that union represented employees have the right to have a union representative present at an investigatory interview, one that could result in some kind of discipline or some consequence of some sort. It prohibits interrogation by employers that interferes with the rights to organize, the rights to bargain, union type things. And whoever may not question the employee about these protected activities. And the union employees, union stuff's something we don't have a whole lot of familiarity with around here. They have what's called Weingarten rights. Management is not required to inform the employee of these rights, but involves things regarding interviews and union representatives. Non-union employees don't have these rights. So anyway, employees have constitutional rights in certain circumstances. We've mentioned before, Constitution protects individuals from the abuse of government power. So constitutional rights would not limit the power of private parties, obviously, but it would restrict the power of government employers, local, state, federal, whatever. For example, a government employee cannot be fired for silence, Fifth Amendment. Private employee can, no problem, right? So, but, remember, this would be in a criminal case and not a civil case. We talked about all that back in the day 2 or 3 weeks ago. But you can make inferences from the silence in the civil case and the criminal proceedings, all that stuff. And we called, we talked about how a criminal and civil case can, the parallel proceedings we called, right? All right. So they're kind of touching on that again. So there's got to be some sort of state action involved for there to be some constitutional violation. And this gets a little bit into one of those practice questions we had on day one, where the law officer, government law officer, whatever, suggested that the manager search their trunk of their car and all this. So, there's got to be some sort of state action if there's a constitutional violation. So investigations conducted by a private company, but at the suggestion of state or federal authorities, all right, that would be a constitutional issue. Investigations conducted by a private company that are required by state or federal law, Constitution's involved there. Searches or interrogations conducted by outside investigators who are off-duty state, local, or federal authorities. That wouldn't be as obvious, so that one's maybe one to take note of. That is that triggers a constitutional, area. And an example would be if a company is being investigated for violation of SEC acts or Foreign Corrupt Practices Acts, that is automatically a state action. Employee Polygraph Protection Act prohibits the use of polygraphs by most private employers unless engaged in an ongoing investigation involving economic loss or injury to the employer in the employer's business, and there's a reasonable suspicion that the employee is involved. That's a lot, isn't it? So, for the most part, no polygraphs. You cannot use them to screen. You cannot use them to discharge an employee, and you can't discharge anybody for refusing a polygraph. It does not protect government employees, though. So, Employee Polygraph Protection Act only protects private sector. Miranda warnings we're familiar with from every cop TV show we've ever seen. Right to remain silent, blah, blah, blah. But, and this is really important for test questions, you'll need to make note of this. These warnings apply only when a person is being interrogated in a custodial setting. Only if they're taken into custody, deprived of freedom in some way. That's when these warnings apply. And we make the note that a private or public employee may interview in a non-custodial setting without giving Miranda warnings. So only if they're being barred from escape or getting out, something like that. And I don't remember if it's here or later or both, but they go into a little bit of detail here, like, they set up a scenario where you have somebody in a room, but you hadn't told them they're not free to leave, but you kind of set a bunch of chairs in front of the door to make it look like they're pinned in there. That would be a custodial setting.
I know one of the questions that answered was about basically you're considered taking the test the moment you feel like you cannot.
The moment someone would feel like they cannot go anywhere there. Yeah. Okay.
Because that was interesting.
That is interesting. I'm weird. When I travel, I look for goofy things. So the original Miranda case happened in, I don't want to say it wrong now. That was a big road trip, and we went a lot of places, but I think it was in Phoenix. So I went and saw the location of where it all went down. Like, hey, that's where the Miranda warning was born, right there. That's the kind of weird things I do when I travel. I think it's in Phoenix. I don't know. Y'all can look it up if you care. All right. So, and there's this warning that I really don't know the proper way to pronounce this. Calkines? I don't know. But anyway, I need to learn how to properly pronounce things. The rule I've always been told, if you don't know how to pronounce things, is just say it like you know what you're talking about. But I can't make myself do that because I don't want to mislead anybody to pronounce something wrong. So I'm real careful about pronouncing things if I'm not sure. So I don't know. Anyway, this warning compels employees to make statements or face disciplinary action, maybe up to being dismissed from their job. But it also provides them with criminal immunity for their statements. So that's an interesting thing, and it comes from some court case with a person who had this name, I guess, where somebody was fired for not cooperating with an internal investigation. The court found that he was not properly advised of his rights to immunity from criminal prosecution. So they're required to give them this warning, and that's what it's called. And then there's the Upjohn warning. If a company attorney is present, the employee should be warned that that attorney represents us, not you. All right. The company doesn't represent you, it represents us. That warning is supposed to be given if the company attorney is there. Just kind of covering your bases. Rules regarding non-union representation during interviews. So a representative may be present if the employer allows. There's no right for the employee to have representation. The employer need not bargain with the representative. This is all non-union. Union stuff's different. Non-union, kind of lose your rights to a lot of this stuff. Representative is not allowed to direct the subject not to answer a question. Not allowed to direct them or to tell them to answer a question only once. Employer is allowed to conduct the interview without interference. So, nutshell right here, non-union representation, you don't have a whole lot of rights there. Fair Labor Standards Act requires the employee to be paid for time spent during an interview. Common law protections. So there's invasion of privacy, protections for the employee here. Intrusion upon seclusion. So that is where someone intrudes where there's a reasonable expectation of privacy. Public disclosure of private fact. It is a statement about, it is what it says. You're publicly disclosing something that is private. It's a statement about private life that's not of public concern course, it has to be some sort of offensive statement for them to have a case against you on it. Even if the statement is true, that can be a problem for somebody who disclosed it. So you can't just say, well, it's true. It's not your business. So you're in trouble now. So all that's under the category of invasion of privacy. Intentional infliction of emotional distress. Can't do that. Defamation. This is a false statement about somebody. So public disclosure of private fact could be true. You're still in trouble. Defamation, it would be a false statement. And we're familiar with libel and slander. Libel is written, slander is oral. Has to be communicated on an unprivileged occasion for it to be a problem. So those are terms you should know already. False imprisonment obviously is restraint of somebody where you're not allowed to do it. Searches and surveillance. So we got all this, the constitutional amendments coming into play here. Well, the Fourth Amendment's coming into play. So Fourth Amendment guarantees the right of all citizens to be free from unreasonable searches and seizures. If you've watched CSI, you know all the things you can do and can't do without a search warrant, right? You know that you could go dig around in their trash. You know, if you've watched CSI, you know all this stuff. So Fourth Amendment, general rule because of this is they need a search warrant. Search warrant, court ordered, right? There has to be a reasonable expectation of privacy. You know, if there's not an expectation of privacy, you don't need a warrant, like the trash thing. Residences are protected, but I like all these things. If the home was open to some public event, then that protection might be lost under that circumstance. Business premises are protected in the offices as long as they're not open to the public. Waiting rooms, reception areas are not protected. Discarded trash and things left outside of a residence are not, I should say, protected. Public places, sidewalks, parks, restaurants, stores are not protected. Mail is protected. Contents of containers that are not transparent are protected. So you kind of get the idea here. You get the theme for when you would and would not need a search warrant. More about the Fourth Amendment. These are exceptions. So exceptions being you wouldn't have to have a search warrant to do these things. Workplace searches by public employees are not protected. So if you work for the government. So no warrants needed there, just reasonableness rather than even probable cause. Just reasonableness is fine, pretty much wide open. And this would be, why would they do this? For something like workplace misconduct, you know, you got to be justified in what you're doing and limited in scope to where you're looking and that kind of thing. But like we said, Fourth Amendment only applies if there's a reasonable expectation of privacy. Searches incident to arrest are an exception. Again, if you've seen TV shows, you kind of know how this works. Police can, without a warrant, do a quick limited search on the arrestee's body and areas within who's being arrested, their control, protective sweep of rooms in the house, if that's where the arrest took place. You can't go looking through drawers and stuff, though. Motor vehicles are a little bit of a different deal. You can search those without a warrant if there's probable cause to believe something's there because there's a higher risk for that stuff disappearing, right? Vehicles can move. So while you're trying to get a warrant, things can happen. So this is a little more urgent. And again, lower expectation of privacy with a vehicle. All right, see right in there. Consent searches. If somebody says, go ahead and search me, they waive their right to the Fourth Amendment protection. You don't even have to warn them that they have the right to refuse it. If they say, go ahead, you can go ahead. Evidence in plain view, obviously, you can get that without a warrant. But again, obviously, the officer must have been lawfully there in the first place. You can't break in somebody and say, oh, plain view, there it is. You know that. Other exceptions, border and custom searches may be conducted even without probable cause or warrant. Searches of prison cells, again, you've seen movies, they can do it whenever they want. Of course, the things you see prison officials do in movies aren't always legal, but yeah, this is. They can search. Not legal to take mail before it's been delivered, but once it's been delivered, ordinary rules regarding searches apply. So there's no federal law that prohibits an employer from opening an employee's mail that's been delivered to the workplace, but could give rise to invasion of privacy and things like that. But before it's delivered, can't do anything. Surveillance of employees, we're shifting gears to that now. We've talked a little bit about some of this. Electronic Communications Privacy Act restricts employers' right to monitor or search their phone, email, internet use, and things like that. You can intentionally intercept, access, disclose, or use somebody else's wire communication, oral communication, or electronic communication. And there's three parts to this: Wiretap Act, Stored Communications Act, and less important, the Pen Register Act. But under the Wiretap Act, you can't intercept stuff. Stored Communications Act, you can't go digging into stuff. So two different acts protect the same thing, but in different stages of it going from one place to the other, right? So the Wiretap Act would prohibit spying on voice and data communications and listening in and things like that. It has nothing to do with things that are already stored. That is covered under Stored Communications Act. So that protects stored information once the system receives it and stores it. Email would be an example, voicemail would be an example. You're not able to access that without authorization. And then this other deal, Pen Register Act. Pen registers are things that can detect a telephone number from which an incoming call has been made. You're not allowed to install that type of thing. So, like I said, that was a little specific and a little less important. So, exceptions to ECPA. So, again, Electronic Communications Privacy Act, wiretap, stored communications. That's what that is all about. Exceptions to that: if it's in the ordinary course of business, quality control, monitoring, and things like that. This is your call will be recorded for quality, that kind of thing. That's an exception. Consent, always an exception to this type of thing. And this exception, we've talked about this already a week or so ago, but if the employer provides and owns the system of communication, then they can do what they want. So the employer can access it as they see fit without violating this. Surveillance of employees, still, now we're on video surveillance. If there's an audio accompaniment to that, then it's covered by the Wiretap Act. That would be intercepting oral communication. Otherwise, this ECPA does not cover video monitoring, but you can install it where there's reasonable expectation of privacy. So just use common sense on that type of thing. The effect of violating an employee's privacy. There's the exclusionary rule. So exclusionary, think excluding, right? Exclusionary. Illegally seized evidence is excluded. It's inadmissible. That applies in criminal and not civil proceedings. So it might be admissible in a civil trial. Public employer cannot use illegally seized evidence to discipline an employee, but a private employer can. But might expose himself to invasion of privacy and things. So it gets a little complicated, but you can just kind of reason your way through some of that types of things if a question comes up. Discharging a suspected wrongdoer. At-will employees, somebody without an employment contract can be discharged at any time for almost any reason. That's good to know. That comes up in real life a lot. If you own a business or if you are a manager of somewhere, it's like, this person's driving me crazy. I wish I could fire him. Go ahead. Of course, then there's ramifications there too, with unemployment and costs and things. But anyway, public employers are governed by stricter standards. So a public employee cannot be terminated for exercising their Fifth Amendment right and things like that. So at-will employees can be discharged for any reason. People with a contract, then you got more issues. Public employers, stricter. Whew, all right, that's a lot. Any questions, comments? Common sense type stuff for the most part, but there's some new things you don't know from everyday life. And some things that are kind of surprising when you read, it's like, really? They can do that? So it's a good section to pay attention to.